Welcome to children and seniors. Sorry we're running a little late. We ran long on the floor, and I think everybody was grabbing a little something to eat. So to start things out this afternoon, we're going to open the hearing on Senate Bill 276, and we'll look to Jesse for an explanation of the bill.
Thank you, Madam Chair. Good afternoon, committee. This is Jesse with the Revisor of Statutes, and I'll provide a brief overview of Senate Bill 276. So what Senate Bill 276 would do is it would establish certain considerations for parents or other individuals who are blind in family law actions, in adoptions, guardianships, and sync cases. So specifically going throughout the bill, Section 1 would establish the purpose of the sections, the 1, 2, and 3, to protect the best interests of children parented by blind individuals or children who could be parented by blind individuals through the establishment of procedural safeguards. Section 2, and then it goes on to have some other findings by the legislature in regards to biases and items that those who are seeking to parent have encountered. Then going on to Section 2 proposes definitions for blind or blindness, family foster home, and supportive parenting services. And those words are important as they are used in Section 3. So Section 3 would prohibit the denial or restriction of legal custody, residency, or parenting time based on a parent's blindness, when otherwise the custody, residency, or parenting time would be in the best interest of the child. And so these actions are, in these actions that are brought under the Kansas Parentage Act or in a dissolution of marriage, that when those who are alleged, when those allege that a parent's blindness is not in the best interest of the child, that person alleging that has to have the burden of proof and provide the evidence proving so. So, and when that burden of proof is considered satisfied by the court, the blind parent then has the opportunity to present their own evidence in the contrary, and as well as in order or requesting the court that they can do so with supportive parenting services. So then the court is authorized to issue an order requiring the supportive parenting services be implemented, and the parties may request to the court a review of the needs of these services throughout. So when a court denies or restricts a blind parent's request for legal custody or residency or the parenting time, the court must include the specific findings of fact for the decision and include reasons why the supportive services were not a reasonable accommodation for preventing that denial or restriction throughout that process explained. And then Section 3 would continue that prohibition on the denial or restrictions unless otherwise in the best interest of the child based on the person's blindness, and many other actions, and those include actions for participation in adoptions, guardianships, family foster home licensure, and in the sync code. So they would go through that same process explained in those actions as well. So this did pass through the Senate. The Senate did amend the bill, but they amended the effective date from the statute book, and they made it Kansas Register, and it passed the Senate chamber 40-0.
Okay, thank you, Jesse. Do we have questions on the bill for Jesse? Representative Wagner.
Okay, Jesse, just trying to kind of understand. So currently, this would be a judge's decision, like in let's say it's a divorce proceeding and where the kids go. So the judge is not required by statute to consider blindness. It's just they just do it. I mean, just sort of because it's an issue. I mean, they're not. There's nothing like in statute that requires them to consider blindness, is there?
No, there currently isn't. So then that creates this absence or question in which now they could address that through the person presenting the evidence if there was an allegation that it was because the parent was blind.
If I can ask, again, just not familiar with the family law on this. So the bill says blindness can't be the primary determinant, but can it be a factor at all? Or is it just totally off limits as a factor in a judge's decision? Or is it just that the burden of proof is on to make that, or what?
Sure. 1 second, Representative.
Is it the clear and convincing evidence that the parent's blindness is not in the best interest of the child? Is that what I should be looking at?
Sure. I mean, if you look at the parent A, the parent B, and the parent C, the lead-in language is that an individual's blindness shall not serve as the basis for that denial. So that's kind of like that core basis of the denial. So that's not necessarily stating it can't be a factor. So it's just stating in the language of the bill that it cannot be the basis, the underlying core reason for the denial or the restriction. But then when there is the person who alleges that a parent's blindness is the reason for there to be a denial or restriction in a case. So for example, if an adverse party files that it is not in the best interest because the parent is blind or has blindness, then they have to have the burden of proof at that. So that's when the burden of proof part comes in, when they first make that allegation.
If I can ask just one more question. And so they talk about having supportive parenting services as far as like being a reasonable accommodation, like under 8 or similar to ADA, which I am familiar with. The supported parenting services, is there a definition of that? And does it say who pays for that? How does that work in this case?
Sure. Yeah. Representative, for the definition for the supportive parenting
I see it now.
service.
Yeah. Okay.
Yeah.
And who? But there's no provision for payment. I mean, the parent.
Yeah, it's currently silent as to who would pay for those services.
All right.
In this bill.
You.
Further questions? Okay, thanks, Jesse. Okay, we'll start with the proponents. And first, we have Robert Tabor with National Federation of the Blind of Kansas. Welcome to the committee.
Good morning, Chairman Concannon and committee members. Thank you for this opportunity to be here today and to speak on behalf and in favor of Senate Bill 276. I want to just mention just a couple of brief side notes that I was listening to the Senate or the House chamber proceeding the other day and had heard Representative Concannon that you became a grandmother. Congratulations. And would also recognize you as one of the 2 legislators who serves on the State Use Law Committee, on which I'm very proud to serve in representing this organization and the important work that we do in promoting the employment of people who are blind and disabled in Kansas. Appreciate that great work. First of all, just a little bit about the National Federation of the Blind. We are an affiliate of that organization, has been around since 1940, and we have affiliates in all 52 jurisdictions, including all 50 states, the District of Columbia, and Puerto Rico. We believe that we believe in the innate normality and capabilities of the blind, and that this is why we are advocating for passage of Senate Bill 276. We have a very starkly disturbing case in Missouri in which the parents of a newborn blind child were in the hospital room enjoying the child's company, and A social worker walked in and literally took the child away on a report because someone was alarmed about the parents being blind, not knowing what their capabilities were. Thanks to the intervention of our Missouri affiliate, the parents went to help, we helped the parents go to contest the action in court, and they got their child back in 57 days. You will hear stories today that are not quite as harrowing, but there have been some issues from time to time with people having their kids taken away simply because they're blind, not because of their actual capabilities. The bill addresses that in a very detailed and comprehensive fashion, and we believe that it would be passed. Now, I would mention the passage by the Senate unanimously in chamber was also mentioned, and certainly each body exercises its own independence because those are the checks and balances of having a bicameral legislature, and we certainly understand and respect that. But I only mention this because the Senate would not have voted the bill unanimously if it did not feel that it was doing the right thing. I thank you again for this opportunity to be here today. That concludes my testimony, and I will stand for any questions.
Thank you. I think we'll go ahead and take questions now. Do we have any? Committee?
Madam Chairman, if I could add one thing very quickly.
Sure.
We have a blind parents division within our organization, headed up nationally by a wonderful and very bright lady by the name of Carlton Cook Walker. And so we do have the resources to provide supportive parenting services when called upon to do so. We stand behind the legislation we support.
Great, thank you. And I think maybe that addresses the question that Representative Wagner had. Okay, thank you. It looks like they're gonna let you off easy without questions. So, thanks for being here.
Thank you.
Next up, we have Susan Tabor. Is she online? Oh, I see. Okay.
Thank you very much. Yeah, go ahead. Thank you. Love the audible cue. Thank you so much.
Thank you. Welcome to the committee.
Thank you. I'm happy to be here. My name is Susan Haller Tabor. I practiced social work in the state for years. And I want to tell you a little story about something that happened while I was in practice. I was working at a mental health center, and I was assigned to work with a young legally blind mother who had lost custody of her child due to concerns that her child was being neglected. The worker was ready for severance when I came on the scene, but I was not. The worker and I had different ideas about the case. I felt that the work with the client had been fragmented, with little continuity and opportunity to fully and objectively assess the client's situation. The material I had received had provided me with information concerning discussions with family members and neighbors, but not many discussions with the mother of the child herself. The severance was requested, and the judge chose to allow the mother to have a course of therapy first. After several months working with me, factors that were problems for this mother were identified, and a plan was put in place to remedy them for the child, and the child was returned to her mother's custody. The skill deficits experienced by this young mother had nothing to do with her visual impairment, though one would not know this when examining the case file before her mental health issues were addressed. The mother herself had experienced a difficult childhood. before becoming a teenage mother, which she had not planned on. She responded well to therapy and to getting the proprieties of her life organized and strategies put in place to help her to honor her life's priorities. This had been a wake-up call. I shudder whenever I think of this case. This young woman nearly lost her child, and unnecessarily due to problems with assumptions made in the delivery of and investigation of child protective services. Placement of this legislation into the statute books and policy manuals of service providers would help more objectively guide their case planning and interventions, thereby leading to a more objective process of assessment and service delivery, and one that directly targets the actual problems, not those created by fear and or unconscious bias. And I'm happy to entertain questions if you have any.
Thank you. Committee, do we have questions? I guess we're a quiet group today.
It's after lunch.
Yeah, well, lunch and a long
Yes.
time in session. So anyway, thank you. Thanks for your testimony. We appreciate you being here. So next up, we have Tom Page from the National Federation of the Blind of Kansas. And I believe he's on WebEx. He's not on? Okay, we'll move on to Luanne Kibby with Skill Resource Center.
Hello.
Oh,
Hi. Can you guys hear me?
yes, we can hear you.
Fantastic. Sorry for the delay there. I am in transit today, and I apologize that I was not able to be in person with you all. Just want to introduce myself as president of National Federation of the Blind of Kansas. In my capacity, over the last 10 years or so, I've received about a call a year on this issue, ranging from fearful parents to mothers who are getting ready to give birth. Something we have done in our organization is we have provided, I don't know what you want to call them, but kind of medical caretakers when somebody is fearful at the time of birth. We have assigned members who are familiar with birth procedures and are medically inclined to go and be with the person at that time at the hospital. That has been a fairly successful strategy that I think is one that we would be happy to not have to implement in the future. Let's see here. I've submitted written testimony as well. So I think probably the best thing to do is to say, in brief, National Federation of the Blind is the largest and oldest advocacy organization of blind citizens in the country. We're comprised of 52 affiliates. That's all the states plus Puerto Rico and D.C. And we're alive and well as an organization here in Kansas. Proud to be one of those 52 affiliates. I can stand for questions.
Okay, thank you, Mr. Page. Committee, do we have questions? Okay, not seeing
Thank
any.
you.
Thank you for joining us. Next up, we have Luanne Kibby with Skill Resource Center.
You hear me?
Almost. Yeah, now we can hear you. Welcome, Luanne.
Thank you. So thank you, Chair Concanon and committee members for allowing me to present testimony today. My name is Luanne Kibby. I am the Systems Advocacy Manager for Skill Resource Center. And Skill advocates for the rights of and provides services to thousands of Kansans with disabilities of all ages and all types of disabilities. So Skill supports Senate Bill 276. We would like to see it amended. We believe and have experienced working with a number of individuals through the years that parents with disabilities are discriminated against by state, private agencies, and courts sometimes based solely on their disabilities, by removing their children from their homes, taking them at the hospital at birth, or making adoption and foster care very difficult. A couple of examples I can provide is one young mother who went to the hospital to give birth and had been pressured for the months previous to that, up to giving birth, and she finally signed the papers. And the reason the state was taking custody, unfortunately, was really based on the fact that she had a developmental and mental health disabilities, as well as a seizure disorder. And unfortunately, when she met with the couple that was taking custody of her, or that was adopting her baby, she had a grand mal seizure, which of course was jeopardizing her health. She had a lot of difficulty dealing for years with that loss of that child. And we still believe that she would have been successful parenting with the right services and supports that Skill and Centers for Independent Living can provide. Another situation we had was a mother who had divorced with her husband, and she had acquired a traumatic brain injury, and she had had full custody of the children, sole custody of the children up to her injury. And after her injury, her ex-husband, who had been convicted of some quite deviant behaviors, actually won custody, or it looked like he was going to win custody. We got an attorney to help her fight it, and she was able to be determined the custodial parent. But it took a lot of time and a lot of work to get to that point. So my point is, in my testimony, is that we really, Skill supports 276, but it has to go beyond protecting parents who are blind. We should have every opportunity as people with disabilities to parent, whether we need services and supports to do so or not. Many of us with disabilities have raised children, just like those of you without disabilities. But it just takes one person to start questioning our ability to parent when the barriers and the discrimination begins. So if amended, Senate Bill 276 would help protect all of us from these types of discrimination and dissolution of our families. So Skill asks that you amend 276 to include people with all types of disabilities. And I will take questions at the appropriate time.
Thanks, Luanne. Have you worked with anyone on language for an amendment?
I believe Mike Burgess, which I think he is also going to provide testimony.
Yeah, okay.
I believe Mike has worked with the revisers.
Okay, thanks.
Or talked with them, so.
Yeah, we've got him up next. Okay, any other questions for Luanne? Representative Wagoner.
Thank you very much for testifying. Because of your experience in particular, I am the question of supportive parenting services for a parent, who is blind or visually impaired. I mean, I see kind of the definition, but what exactly in a practical sense these are, I mean, is this a skill you teach them, or how does it raise the bar for what a visually impaired parent can actually do in raising a child? I mean, what's, I don't know, can you provide a little more elaboration on what that would be like?
Well, and a lot of it depends on the disability, because as I said, we work with people with all types of disabilities and have worked with parents with all types of disabilities. And sometimes it's adaptive equipment. If you use a wheelchair, you might have a baby crib that is modified to where you don't have to reach over the top, it opens to the side and you can reach the baby easier. Sometimes if it's individual with intellectual developmental disabilities, some of it's just training and teaching them how to feed the child, change the diapers. I mean, just the parenting skills that, and really no different from a lot of young people without disabilities. have to learn those parenting skills too. But sometimes it may take an individual a little bit longer and a little bit more training to get to that point. So it depends on the parent themselves as to what they might need.
Okay, I think that's helpful. Thank you.
Further questions? Representative Helmer.
I'm sorry, I can't find it. How, I appreciate your organization, but how far out do you reach? How many people are you able to touch and train annually or ongoing? Or how large of a vicinity are you able to cover?
Okay, so there's 10 centers for independent living across the state. So through those 10 centers, every county is designated within one of those service areas. And we provide a variety of services. We do provide some services under the Home and Community-Based Services Program, but we also provide what we call independent living skills training to people with all types of disabilities, all ages. And some of these individuals may be and have been parents or upcoming parents who happen to have disabilities. So basically the whole 105 counties would be covered by the Centers for Independent Living and able to provide those type of services. So.
Thank you very much. Thank you, Madam Chair.
Further questions? Representative Wagner.
If I can go back to the supportive parenting services. So is it your group sort of offers that? It's training or is it also ongoing? Is there like on average it costs $500 a month? It costs, I don't know, is there like an ongoing cost? And how is that money or how is that cost covered in most of the cases you work with?
So the 10 centers get it's independent living funds. So 6 of the centers receive some federal funds, and 5 of those also receive some state funds. And then 4 of the centers do not receive federal funds. They do receive state funds. And that goes through Kansas Rehab Services is our designated state entity that those funds are funneled through. And so these types of services that we would assist parents with disabilities through is a service that we offer to anyone with a disability, and it's called Independent Living Skills Training. And I mean, it can be independent living skills training can be cooking skills or budgeting skills for one person. And then for another person who needs parenting skills, then we would teach them parenting skills. So, but independent living skills training is one of our core services that centers must provide under federal and state law that we exist. So does that make sense?
Wait, but is there a charge at all to the person receiving it, or is this just a government program that there's no cost to the recipient?
Right. None of our services, we don't charge anyone for any of our services. It's all funded either through federal or state funds or both, donations, grants. It just depends on the center.
Further questions? Okay. Thank you. Okay, next up we have Mike Burgess with Disability Rights Center of Kansas.
Howdy, can you hear me okay?
Yes, we can hear you, Mike. Welcome to the committee.
Perfect. Well, thank you, and thank you. I wish I could be there in person, but unfortunately I'm away, and so appreciate the opportunity to be remote. So as the chair said, I'm Mike Burgess, and I'm the Director of Policy and Outreach at the Disability Rights Center of Kansas. You hopefully have my testimony in front of you. We are very supportive of the bill as drafted, but like the previous conferee said, we would be very supportive and would request the committee to consider broadening it I do want to thank this committee's work previously on the ensuring non-discrimination in organ transplants. And while it's a very different topic, it's kind of a similar problem where we're trying to work through those unconscious biases that exist, unfortunately, in some places and make it difficult. And so, like the previous conferee said, I mean, the case in Missouri was certainly a very, very bad example of the need for this. And there are cases here in Kansas that I know of. I mean, I know of a parent who's had a lot of challenges around this as well. So it is a problem here in Kansas as well. And so I appreciate the committee scheduling this right away. In my testimony, I have a link to a study that the National Council on Disability did in 2012. And it was titled "Rocking the Cradle, Ensuring the Rights of Parents with Disabilities and Their Children." And if you look down in my testimony too, and I won't read all the statistics, but you can see how alarmingly high the problems are for a wide variety of disabilities and how often parents are losing their kids. And obviously, in some cases, it's because of that. I mean, certainly if there is a risk, that risk should be considered, but it shouldn't be just simply because of their disability or because of their blindness that they're having challenges in a custody hearing. And so anyways, so as I said, the bill also seeks to address one of the findings in that NCD report that I've also listed in my testimony. So, and as the chair had asked the previous conferee, I have requested an amendment. I don't have a copy of it yet, but we would hopefully be able to get that soon. I have inquired about when I might be able to get it and haven't got a response back yet, but I know it's in the queue somewhere. But with that, Madam Chair, I'd be happy to stand for questions now or at the appropriate time.
Okay, thank you, Mike. Mike, do you know if there, or maybe this would be a question for Jesse, but is there anything already in the sync code or federal law that protects the disabled?
I might defer to the advisor on that one. I'm not familiar enough with that.
Okay. Do you need a minute? Okay, Jesse.
Madam Chair, I'm not aware of anything in regards to non-discrimination in sync actions, but I can look that up and get that information to the committee.
All right, thank you. Other questions for Mike? Okay, thanks, Mike.
Thank you.
Okay, that's all we have for oral testimony. Committee, I direct your attention to quite a few pieces of proponent written testimony. Yes, ma'am. Okay. Okay. Come on forward. And Susan Stanzel. Okay. Okay, we just had you on the wrong list. Sorry about that.
That's okay.
Welcome to the committee.
Thank you so much. Greetings, Representative Chairperson Concanon. My name is Susie Stanzel, and I have been blind since birth, born 3 months early. I have been blind and went to the Kansas State School for the Blind. Then I went to Shawnee Mission East. Further went to Emporia for college, where I got a Bachelor of Science in Business with an emphasis in data processing. Back then, there were only 31 hours of data processing I could have. I'm 72. I got married at 26 and had my first child, Loretta, at 31. Things went very well. She had trouble learning to nurse. I talked with my friends through the Federation. I talked with people that were sighted also. And she and I finally got the idea of how it's supposed to work. It's not always easy. And I stayed home with her for about 3 months until I returned to my work as a computer systems specialist. I had 2 more girls, Virginia and Crystal. Crystal paid me the greatest compliment during the pandemic last year. I am a widow, therefore I did not have any help for this. I kept both of her children, which were 2 and 4 at the time, 1 and 4 actually, from Tuesday morning until Thursday evening, through the nights and everything. Crystal felt confident in leaving me with her children. I didn't have any problems at all. Couldn't go outside. It was wintertime, and we couldn't go out anyway. All of my children are successful young women. My oldest daughter, Loretta, works for the Nike Corporation. I will not say there weren't any problems. I guess I should say that a little differently. We had the normal problems that happen with children. Cleaning the room, getting dressed, getting out for school on time, all these normal things. We did have one steadfast rule. If there was a toy that Mommy found on the stairs, the toy disappeared, never to appear again. They could not buy it back. It was gone. My children knew this and understood it. I had a tiny bit of problem with my middle child who had ADHD. I bought a little, restraining device that I put on her chest, and I held on to it when we were shopping because she liked to run and hide in the racks of clothes. And I had a desire to keep her with me. Today, I won't even, when I'm out with when we took a baby out, we just kept a hold of the baby carriage all the time because people can run over and decide that they'd like your baby more than you would like your baby. I never thought of such a thing at the time I was a blind parent. I appreciate you allowing me to speak today. As you can see, blindness did not cause any specific problems, and I did have some written testimony. Thank you so much. Please pass this bill.
Thank you. Did we have any, can you hang on just a minute?
It's okay.
Okay.
If I could comment, I had 2 of my grandchildren yesterday that are 1 year old. They're both 1. And that's very difficult, so I can only compliment these people for what they do. I don't know how they do it because I couldn't do it myself, so.
I sat for an hour in the
Do you have to clear all the furniture and everything out of the room, or?
No, but I don't let toys lay around. I do not allow that. Now my granddaughter comes over just to make brownies with me for fun.
All my grandchildren do is dump the toys on the ground, and we pick them up, and then they dump them. So thank you for what you do.
My 3-year-old grandson is rather good at that at this time.
God bless you all.
Okay, thank you. Was there anyone else that wished? Oh. Hi, welcome to committee.
Good afternoon. My name is Miles Anderson. I am from Overland Park, Kansas, and I am in House District 22. Madam Chairman and members of the committee, blind people are normal people who happen not to see and are a cross-section of society. As a former resident of Minnesota and as a retired teacher of rehabilitation at a center for the blind in the state of Colorado, and currently as a resident of Kansas, I know several children who have been raised by blind parents, and the children, some of them have been blind, some have been cited, and there has been no problem with this. I'm not a parent, but I do know the capabilities of blind people. I taught blind people in Zambia how to travel independently using the cane in 1982, and I taught blind people in Poland how to travel in 1996 and 1997. Unfortunately, age-old misconceptions regarding blindness have caused children to be taken away from their parents. Parents, whether blind or sighted, face a learning curve when raising children. You know, it is not only the physical senses that are required to overcome these learning challenges, it is the thoughts that come to us, that we get wisdom that help us to overcome various challenges. It's unfortunate that that people are discriminated against because of blindness. And I am hopeful that this bill, as amended, will pass this committee, pass the House of Representatives, and be signed by the governor. Thank you very much. And if you have any further questions, I'd be happy to answer them.
Okay, thank you. Do we have questions? Representative Smith.
Thank you, Madam Chair. I was wondering, you know, I have a good friend that's blind. He went to the Kansas City, Kansas School of the Blind and got help and did very well, But I'm wondering if somebody lives in rural Kansas, how can they get services? They're just so far away from everything. How would they get services and help?
Blind people here in the state of Kansas, they would need to connect with rehabilitation services with DCF and, you know, get connected with them. And then there is currently no rehabilitation center for blind people in the state of Kansas, but blind people have been sent to other centers such as in Missouri and in Colorado for training. And the center in Colorado, I can speak to the center in Colorado. The training is very rigorous, and we have that center has very high expectations for blind people. In addition to teaching such things as Braille and travel and daily living and job-seeking skills, we did other things, experiential education, things such as whitewater rafting, rock climbing, and skiing.
Thank you, Madam Chair. When you would say you went to Colorado, would the child go with you so you worked with the child as well as you were learning?
I think usually I think that would have to be worked out with the school and with the parents and so forth. Well, I do know I have a child of some parents that have faced some discrimination problems in the state of Oregon that came to Colorado and for training, and the child, was with the parents, and things went very well for the child, and there was no issue or problems.
Thank you. Thank you, Madam Chair.
Representative Penn.
Thank you, Madam Chair. Good afternoon to all of our conferees. I wanted to thank you for your testimony here today. I've met Mr. Mike Burgess in my office before, so I completely support the hard work that he does with the Disability Rights Center of Kansas. To Dr. Anderson, thank you for your testimony today. To Ms. Susie, you are an inspiration, madam. I have my kids running around. I just listen for the bumps myself, you know. But I just wanted to say very briefly, and thank you, Madam Chair, for allowing the time. You all are phenomenal. You are phenomenal beyond comprehension, and your stories, they are a testimony and testament to both the strength, the power, the love, the resolve that our God places in each of us, but in you in unequaled measure. I just wanted to thank each of you for your witness here today. I want to let you know that as a former foster child myself, I know what it is that foster children desire more than anything, and is a place to belong, and is a home with love. So I will strongly support you in this bill, and you let me know what you need. Thank you, Madam Chair.
Online, we have Representative Neighbor with a question.
Thank you, Madam Chair. I think it was probably Susie, when she was at the State School for the Visually Handicapped, was she a resident student there, or was she driven from home to school each day? I asked that question because I worked at the School for the Visually Handicapped when I was in college for the superintendent, principal, and the psychologist. And I can tell you that if any of you have had that kind of an opportunity at that time, it was a school that was on site, and kids from all over the state of Kansas could come because you could live on the property at that time. I don't know if it still does that, but I can tell you that if you go there, they have a swimming pool. I used to take a young band around that played at different parties, and you would be surprised at how quickly one can put a drum set together and all the other things that were needed. But one of the things you all might try when you go home, if you want to understand, is go in a quiet hallway, close your eyes and start walking to the wall, but start listening with your ears, because it gets much more, I don't want to say tight, but you can tell you're getting in front of a more solid opponent for you. So those are some things that you can do, but it's amazing what our visually handicapped people can do, and they're actually very awesome. So thank you, Madam Chair.
Okay, any further questions? Okay, thank you, sir. Okay, what, you can go ahead and respond where you're at if you'd like.
Representative, first of all, thank you for your very important question. I'm a Western Kansas man myself. I grew up out in Garden City, Finney County, and I was the product from grade 4 on up through 12 of the special education system, because Garden City was part of a special ed co-op that was out there, and this was even before the Individuals with Disabilities Education Act came about in 1975. So this was a long, long time ago. I had a wonderful resource teacher who worked with me daily. We also had home teachers at the time that worked for the state, and they would come and teach some cane travel skills. So there certainly is that option. And the federal laws I mentioned, the IDEA does provide for free and appropriate education services for children with disabilities and blindness. There is also the option that parents have of enrolling them in the State School for the Blind in Kansas City, Kansas. And I hope that addresses those concerns that you have and certainly share.
Thank you. Okay, was there anyone else who would like to testify verbally? Okay, I will draw your attention to, like I said before, multiple pieces of written testimony that they've taken the time to write, and please take the time to read it. At this point, I'm going to turn back to Jesse to answer the question that I asked before.
Thank you, Madam Chair. In regards to anything in current state law or federal law that prohibits discrimination based on a disability, specifically in the SYNC code, you can go to KSA 38-2201. That's subsection C. What this statute does is it generally is the construction of the code and the policy of the state when it comes to the sync code. So in that subsection C, it states that nothing in this code shall be construed to permit discrimination on the basis of disability. The disability of a parent shall not constitute a basis for the determination that a child is a child in need of care, or for the removal of custody of a child from that parent, or from the termination of parental rights without a specific showing that there is a causal relation between the disability and the harm to the child. Also, that in cases involving a parent with a disability, determinations made under this code shall consider the availability and use of accommodations for the disability, including adaptive equipment and supportive services. So that is 382201 in the statutes. And when you look to federal law, the ADA, Title II, and then Section 504 of the Rehabilitation Act, those have non-discrimination clauses, and they apply to child welfare agencies that either receive or don't receive federal monies, and states that those agencies generally cannot act on unfounded assumptions, generalizations, or stereotypes of a person with a disability. And that's all I have right now as far as the federal law goes, in regards to the general actions of those child welfare agencies in the federal part.
Thank you. Thanks. You're so quick. Okay, that's all we have then for proponents. I'm not showing any opponents or neutral. Is there anyone here? Oh, Representative Wagner.
I just want to suggest what Jesse had found that's currently in code, if she could send that to the members, because that seemed very relevant.
No, yeah, thank you. Thanks. Good thought. Anyone wishing to speak neutral or opponent? Okay, with that, we'll close the hearing on Senate Bill 276. And before we take a look at House Bill 2700, I was wondering, Representative Johnson, if you might make an introduction of this nice young gentleman that's been helping.
Yes, go ahead. And your dad. Oh, that's your dad next to you. Stand up and introduce yourself. Yeah. Go ahead, introduce yourself nice and loud. Yep, and he has a page for me today.
Thank you both for being here, and thanks, Representative Johnson. Okay, we're going to take a look at House Bill 2700, and Jesse, do you want to give us just a quick summary on that one?
Thank you, Madam Chair. Yes, House Bill 2700 amends KSA 382270. So this is the statute that authorizes the court to enter orders granting custody of a child specifically for adoption when the parental rights are terminated. And so what it would require is that the department make an individualized assessment before giving a consent to the adoption that is in the order that can be granted pursuant to this section, and it be conducted by the person, secretary, or corporation that is currently has custody of the child. The assessment includes specifically looking at attachments of the child and the needs in regards to those attachments. And once that assessment is completed, the person, secretary, or corporation would provide that assessment to the court, and then the court would be required to make a finding that that assessment has been completed.
Okay, thank you. Are there any questions regarding the bill for Jesse? Then committee, what would your wishes be on the on this bill? Representative Esau.
Thank you, Madam Chair. I would like to move for discussion and possible action here, HB 2700. Yes, favorable for passage.
And
hopefully you got that in English. I move HB 2700 favorable for passage.
Okay, it's been moved by Representative Esau, second by Representative Mosier to pass out favorably. Is there discussion? And I have an amendment. Do you have it? Okay. Jesse, would you explain the amendment?
Yes, thank you, Madam Chair. Thank you for your patience. So the amendment that's being proposed, I have, with the help of Connor, distributed to the committee because this is quite a few pages, but it is very minimal changes. So first of all, you'll see changes in the title in regards to the anticipated changes in the bill. And so for Section 1, Section 1 is actually now going to be an amendatory section. So if you go to the third page, it's inserting KSA 382202, and that's hereby amended to read as follows. And then on the next page, the amendment only amends one definition, and that's in parent Q. And so it's amending the definition of kinship care placement. So it currently already means the placement of a child in the home of an adult with whom the child or the child's parents already have close emotional ties. But now the amendment proposes that include a foster placement with whom the child lived for more than 6 months. So that's the definition. And as an amendatory section, that would be the first section. So then if you go back to what was Section 1, the all new language, when you go to parent B1, you're striking the prior to making an order under subsection A1, and instead inserts that when there is more than one prospective adoptive family. So making that instead of a requirement prior to, it now under this amendment would be only when there is more than one prospective adoptive family. And then that similar change is made in subsection C. And then the rest is cleanup in regards to making sure that amendatory section is there and they're grammatically correct.
We haven't made a motion to amend. I move we amend, and second by Representative Ousley. Now we'll have discussion. Representative Esau.
So I want to make sure I'm right. Is this only in consideration of adoption cases, not foster family placement?
In regards to the original bill, that new language was about adoption of children that were in the custody of the secretary. And that was the secretary giving the consent. Yes.
So it doesn't address anything having to do with foster care placement long-term or anything like that. Okay, my second question, was there, and this may be for the person who has the amendment, a reason that we chose 6 months? And I'm willing to wait until.
Jesse, do you have an answer on that?
I would defer to those who know more about the amendment.
Well, I would defer to those who had the Representative Humphreys. I don't usually do this when we're working a bill, but since this was your bill and actually your amendment, would you share that information?
When you look at the definition of kinship placement, it said a placement where the child or the parent has close emotional ties. And we chose 6 months because it seemed like close emotional ties could be developed in 6 months. Of course, a year is fine. those are also close ties, but we felt like less than 6 months, 6 months gives time for those close emotional ties to be developed, is how we chose 6 months.
And while we have you.
Yes.
It's my understanding that this amendment will help the fiscal note.
Yeah, because before, there were going to be a lot of hearings, it seemed like, and now it's limited to when there are only two, or when there are more than one adoption choices. And so that's when it would be limited. And so it's way different than just everyone, hearing all the time. So that was that reason.
Thank you. I'm going to allow, if anybody else has a question for Representative Humphreys, Representative Penn.
Thank you so much, Madam Chair. I'm so sorry, I'm just getting back in. You probably already explained it, Ms. Jessie, but where you say that you are repealing 38 TAC 2202, that's the definitions, that section on page 3 of this. Can you explain why that is and what does that affect?
Jessie. Yeah.
Thank you, Madam Chair. Yes, Representative Penn. So what the amendment does is it now includes that section in it. You can find that on page 3. So now it includes KSA 33-2202, and it amends a definition in there. Procedurally, when you amend something, you repeal the previous statute and input the new one. So that's why that change is being made, to make sure that's proper procedure.
Thank you. And Madam Chair, if I may ask Representative Humphreys one. Chair Humphreys, just a quick question. You may have answered it already. This now deals with when there's competition in multiple adoptive resources, but does it also pertain to fostering resources?
This is only dealing with when there's adoption choices. We may get to that, and actually, we hope to dig into that at some point. But for now, we're talking about, attachment considerations when there's adoption choices.
Thank you, Madam Chair.
Representative Ousley.
Thank you, Madam Chair, and thank you, Representative Humphreys. In looking at the balloon and the definitions, including a foster placement with whom the child lived for more than 6 months, what would it do to the bill if we put including but not limited to? I mean, because it seems like if we did that, maybe we wouldn't be tied to that 6 months so much as we would the attachment.
I'm not sure I understand, but it's for the committee to talk about and for them to decide. So you're saying, maybe say that again, because if I didn't understand, I hope not everyone, that other people didn't understand that. That's right, exactly.
I often don't word my questions clear, and then I don't speak clear, so I do everybody a disservice. On the balloon and the definitions, it says including a foster placement. What about including, but not limited to? Because I know when we've worked bills in the past, we often put including but not limited to. And just seeing this now for the first time, it seems like if we did that, we wouldn't be tied to the time period so much as we would be focusing upon the attachment. But I don't want to change the intent of your amendment here.
I see. So you would just say including but not limited to a foster placement period?
No, we'd leave.
You'd leave in the 6 months?
Yeah.
We talked about if we should just say including a placement with whom the child has lived for more than 6 months. But, that could include a group home. It might just muddy the water, we thought. So we just specifically said foster. But again, this is for the will of the committee to decide about the amendment.
Okay, and I'm following you on that. I just looked at it as this was more about the 6 months than the placement. But okay, never mind. I'm off base.
Yeah, we'd actually had a discussion about it, and I wanted him to ask you because we didn't want, if that opens it back up to everything, we don't want to blow up that fiscal note again. Okay. Any other questions? Oh, yeah, Representative Vaughn. Sorry, I forgot you.
No worries. Thank you, Madam Chair, and thank you, Representative. I know when you testified, you mentioned a technical amendment. Does this encompass a lot of those concerns?
If I said technical, I may have meant some technical things, but also knowing that we might just need to adjust to make sure we got it right. And so this does encompass, and we've gone back and forth, and in fact, so this is even delayed. I kind of hoped to work the bill before turnaround, but we couldn't, but through working with DCF and other groups, this is what we came up with. So this seems like it's everything that we wanted. Thank you.
Thank you. And
Representative Penn.
if I may, Madam Chair, just for you, I know you mentioned the fiscal note, and I see the one that's online. Is the one online the updated fiscal note, as far as you're aware?
I don't believe there's an updated fiscal note yet.
Okay. Thank you.
Representative Penn.
I'm sorry for the confusion. Thank you for the grace. Representative Humphries, just going back to what the ranking member was talking about in that balloon where it was talking about the 6 months, if I'm to be clear, you were saying in there that it's more focused on the placement, the type of placement, a foster placement that has that connective tissue for at least 6 months. Would it be appropriate to say in there for that foster placement for a time period not limited to but including 6 months, or does that open up, as Madam Chair said, a whole lot more hearings and everything? Because I'm just trying to understand what he was getting at. Was he saying that, hey, that you have the opportunity to be in a placement, get that type of relationship built from 0 to 6 months? Are we encompassing that space of time, or is this only applicable at the 6 month mark?
So a couple things. I think, specifically when we were talking about attachment and there's more than one adoptive resource, it is almost always the foster family who's wanting to adopt, and maybe there's someone else. And so that's why we said here foster placement, because again, it didn't want it to be like a group home. I mean, just didn't want it to be confusing. And then we said 6 months because that seemed adequate for developing those emotional ties. So just reviewing it and talking to people, this seemed like the thing, so.
Representative Wagoner.
Yes, Representative Humphries. Why did they strike siblings out on page 2? What's so?
Yeah, and that could be maybe the technical thing. That was DCF's suggestion, and they just said siblings are included in the definition of relatives in the sync code so that it was redundant.
Okay, thank you, Representative Humphries. I think this is kind of, just a minute. Representative, this is kind of turned back into a hearing. Representative Owsley.
And this may help turn it back into a hearing. Have there been conversations with any of the proponents or neutrals about the amendment?
Yes, DCF actually offered quite a bit of these changes. And then the other proponents that were like foster families that had something, I didn't go back to them. I mean, they just want attachment considered, and that is still very much intact with what we're doing.
I looked up the hearing and there were 7 proponents and a neutral, so
And also Rachel, who is here, Rachel Marsh is here also, and she also worked hard with us to get these amendments right. So
I can do my follow-up.
the policy proponents were all included, and then the others, so much I didn't go back to. Thank you.
Madam Chair.
Okay, so let's get back to working the bill. And thanks for being here and helping us, and thanks both of you for your work on preparing this amendment. Is there any other discussion on the amendment? Okay, I'm going to close on my amendment. All in favor say aye. Aye. Opposed, no? Okay, the amendment passes. We're back on the bill. We need a new motion as amended. Okay, any further discussion on the bill? Okay, Representative Esau, you may close.
Thank you, Madam Chair. And the discussion I heard brought up many of my things that I didn't want to say it as part of the question, just I'll put it here in my close, that the 6 months seemed kind of, like black and white arbitrary, but if it cuts down on the cost, and when we're looking at multiple families interested in adoption, then 6 months perhaps seems reasonable. I think this is a very good start for looking at attachment and making sure that in statute we say what we all want, that we're considering attachment as a very high priority for the children. And so with that, I would move that that we pass out House Bill 2700 favorably as amended.
Thank you. The motion is to pass out House Bill 2700 favorably as amended. No, we already had a second. Yeah. All in favor say aye. Opposed, no. All right, bill's passed. That's all we have for our work today. What do we have? What we're gonna? Yeah. The Foster Care Bill of Rights and Foster Child Bill of Rights tomorrow. Okay. Thanks, everybody.